Hello, everyone. So we are in our second part of the Code of Criminal Procedure, Second Amendment Ordinance 2025. So point number 6 talks about Act number 5 of 1898 in নতুন section 54 এর সন্নিবেশ উক্ত কোডের সেকশন 54 এর পর নিম্নরূপ নতুন সেকশন 54 এ সন্নিবেশিত হইবে যথা সেকশন 54 এ section 54 talked about when police may arrest without warrant. So previously in the previous video we have seen what is the new section 54 is about. Now we have another section which is section 54 a, which talks about person arrested to be informed of reason of arrest. Every police officer arresting any person without warrant shall, at the time of making arrest, communicate to him the reasons for which he is arrested. So this is what section 54 is for 54A is about. And then we move on to point number 7, which talks about section 67A. So section 67 previously was about the provisions of sections 47, 48, and 49 to apply to arrest under section 68. So section 67 actually is a different thing in the Code of Criminal Procedure 1898. Now we have an addition after section 67, which is 67A, which talks about procedure in case of non-compliance with provisions relating to address. The magistrate or court, as the case may be, before whom the arrested person is produced, shall examine whether the provision of this code relating to arrest have been duly complied with by the officer making the arrest, and if the magistrate or court finds that any such provision or provisions have been negligently violated or not complied with, he or it may, for reasons to be recorded in writing, direct appropriate action to be taken against the concerned officer in accordance with applicable service rules. So this is the result. I think section 67A is very important because we have this new, very descriptive, very proper sections and provisions that are there. But if it's not followed, what will happen? So this is the result consequence for the person who will be arresting. They will face consequences under section 67A of Code of Criminal Procedure of the Code of Criminal Procedure. Code of Criminal Procedure 1898 basically. So point number 8 is section 69. Section 69 actually previously talked about summon house served. So this is the previous section. So there will be an addition of subsection 4 here. The previous sections will be, the previous provision will be there. There will be an addition of subsection 4 that talks about the court may, in addition to the modes of service provided in the foregoing sections, which is in the previous act, direct that the summons be served through electronic means such as short message services, voice call, instant messaging services, or electronic mail, and the proof of such services shall be preserved with the record. This is also a major, I think, addition. Then point number 9 is section 70. In section 70, the word mail will not be there. শব্দটি বিলুপ্ত হইবে. So yeah. So section 70 is about let me see, a service when someone cannot be found. So this is the section. Point number 10, section 167 এর সংশোধন. এর section 167 এর কয় subsection 2 এর পরিবর্তন নিম্নরূপে subsection 2 পরিস্থাপিত হইবে যথা. So the subsection 2 of section 167, which talks about, let me find what section 167 is about. 167 is about procedure when investigation cannot be completed in 24 hours. So this section, subsection 2, will be amended. Basically, the magistrate to whom an accused person is forwarded under this section or produced otherwise may, whether he has or has not jurisdiction to try the case from time to time, authorize the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole. And if he has not jurisdiction to try the case or send it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that no magistrate of the third class and no magistrate of the second class not specially empowered in this behalf by the government should authorize detention in the custody of the police. Provided further that no magistrate shall, under any particular case, authorize the detention of an accused person in police custody for a period exceeding 15 days in the whole, and where further detention is considered necessary, the magistrate may, upon production of the accused, either in person or through electronic video linkage, authorize such detention in judicial custody. Explanation: for the purpose of this chapter, judicial custody means custody of an accused in jail or in any other custody other than the custody of the police under the order of a magistrate or court during investigation. Then there is 2A, which is changed probably, and 2A talks about of section 167 talks about right now a magistrate authorizing the detention of an accused person in police custody under subsection 2 may order that the accused be examined by medical officer of nearest government hospital before he is handed over to such custody, and upon expiration of the period of police custody the accused shall be produced before the magistrate without necessary delay. And if upon such production this appears to be any mark of injury on the body of the person accused, or the accused alleges that he has been subject to torture during the custody, the magistrate shall direct that the custody be examined by accused be examined by a medical officer of the nearest government hospital, and where the medical reports reveal that the accused has been subject to torture during police custody, the magistrate shall proceed in accordance with law. So what is the procedure that the magistrate shall proceed in accordance with law is not known to us right now. Point number 11, we have 167A right now, which was not there previously. So this is definitely an addition of from under 167 to 167A, duties of magistrate in relation to shown arrest and detention. Subsection 1, where the police officer making the investigation in a case seeks a person who is already in custody in another case to be shown arrested in that case, the magistrate shall not allow such prayer unless the arrested person is produced before him, along with a copy of the entries in the diary relating to such case and given opportunity of being heard, and unless the application appears to be well founded. Subsection 2, the magistrate shall not authorize the detention of any person in judicial custody where the police forwarding report discloses that the arrest has been made for the purpose of detaining him under any law providing for preventive detention. Subsection 3, if the magistrate has reason to believe that any officer who has legal authority to commit a person in confinement has acted contrary to law, he shall proceed against such officer under section 220 of the Penal Code. Okay. So now we move to section 173B. So previously, section 173, which is still in existence, is about report of police officer. We now have section 173B. Did we have? Yeah, the previous one was 160. Okay, 173B is there right now. We have new addition, which is provision for completion of investigation. Let's see what this section talks about. Subsection 1 of 173 talks about, notwithstanding anything contained in this code, every investigation in this chapter shall be completed within 60 days from the date of receipt of the information relating to the offense. Okay. Subsection 2 is where for a reasonable cause the investigation cannot be completed within the period specified in subsection 1, which is 60 working days. The investigating officer shall record the reasons for such delay in the case diary, apply to the magistrate for extension of time, stating the specific grounds and the additional time required, and forward a copy of such application to the superior officer supervising the investigation. Subsection 3, upon consideration of the application made under subsection 2, the magistrate may, by order, extend the time for investigation as may be deemed necessary, reasonable, and the investigating officer shall conclude the investigation within the extended time. Subsection 4, where the investigation is not completed within the time so extended under subsection 3, the investigation officer shall, upon expiry of such period, report the reasons in writing to the magistrate and send a copy thereof the superior officer supervising the investigation. Subsection 5, upon consideration of the explanation submitted under subsection 4, or where no such explanation is submitted by the investigation officer, the magistrate may direct that the investigation be conducted by another officer. Treat such delay or as incompetence or misconduct on the part of the investigation officer, cause a note thereof to be recorded in the officer's annual confidential report, and direct the appropriate authority to take action in accordance with relevant service rules. Subsection 6, if upon submission of the investigation report, the court is satisfied, having regard to the materials on record, that any person named as an accused ought in the interest of justice to be treated as a witness, the court may pass an order to that effect, and such person shall be treated as a witness in the case. If upon subsection 7, if upon conclusion of the trial, the court finds that the investigating officer either negligently or with intent to protect any person from criminal liability failed to consider any admission, failed to collect or consider any admissible evidence, treated any person as witness who ought to have been made an accused, or failed to examine a material witness without jurisdiction, the court may record a finding to that effect, treat such act or omission as misconduct or incompetence, and direct the controlling authority to take appropriate legal actions against the officer in accordance with law. Point number 13, we have section 247. 247 talks about, let me find it, what is 247's heading. 247 is about non-appearance of complainant. Now we have that this will be included, that if the summon has been issued on complaint and upon the words in our current code, if the person has been issued on a complaint and upon will be changed, and the now provision will be in a case instituted upon complaint if on. So these are the changes. Now it's the colored one will be substituted in the previous sentence. Okay, so now moving on to section 250. 250 is about false, frivolous, or false, frivolous, or vexatious accusations. Pardon my mistake. So moving on. So in this section, it's pretty simple. Where there was previous may, now there will be shall, and where there was the amounts are increased in this section. Previously, it was 1,000 taka. Now there will be 50,000 taka. Then there will be instead of having 500 taka, now will be 25,000 taka. 100 taka will be changed to 5,000 taka. 3,000 taka will be changed to 1 lakh taka. So These are the substitution, nothing major, it's just the amount. And section 260 is about power to try summarily. So in summary trial, the amounts are also increased. The 10,000 taka is increased to 5 lakh taka in all of the places where there is 10,000 taka. So these are simple amendments. Now moving on to section 264A. So 264 previously was about recording appealable cases. Recording appealable cases, this is basically under summary trial. And so, yeah, so 264A will be added, special procedure for summary trial, which is a very important aspect, notwithstanding anything contained in section 262. The framing of charges, recording of evidence, examination of the accused under section 342, and pronouncement of judgment may, if practical, be completed in the same session at any place within the jurisdiction of the court. So this is a new addition to the code of criminal procedure, and under the summary trials part, which is in chapter 22. Now we are moving on to point number 17 and section 339B. 339B. We had 339B in the previous code, which is trial in absentia. উক্ত কোডের সেকশন 339B এর সাবসেকশন 1 এর পরিবর্তে নিম্নরূপ সাবসেকশন 1 পরিস্থাপিত হইবে. So the previous subsection 1 will not be there, and this new subsection 1 will be there right now. So which talks about notwithstanding anything contained in section 87 and in section 88, where the court has reason to believe that an accused person has absconded or concealing himself so that he cannot be arrested and produced for trial, and there is no immediate prospect of arresting him, the court, taking cognizance of the offense complained of, shall by order published in one national daily newspaper having wide circulation direct such person to appear before it within such period as may be specified in the order, and if such person fails to comply with the such direction, he shall be tried in his absence, provided that the court may in addition direct that the order for appearance of the accused be published on the official website of the district and session judges court, the Chief Judicial Magistrate Court and Chief Metropolitan Magistrate Court, the Officer of Deputy Commissioner, the Bangladesh Police, or any other government website having wide public accessibility. So these are some new things that weren't there in the previous provision. So moving on to section 345. So 345 is about compounding offenses. Let me read it in what is written here, and then I'm going to translate it in English. উক্ত কোডের সেকশন 345 এর সাবসেকশন 2 এর সারণীর রায়োটিং এর উপরে নতুন সারি যুক্ত হইবে, যেখানে অফেন্স কলামের বিপরীতে বিং মেম্বার অফ আনলফুল অ্যাসেম্বলি শব্দগুলি sections of penal code applicable কলামের বিপরীতে 143 সংখ্যা এবং person by whom offense may be compounded কলামের বিপরীতে the person against whom the unlawful assembly was assembled শব্দগুলি উল্লেখিত থাকবে. So offense কলামের বিপরীতে, so there will be some new columns will be added, like being member of unlawful assembly 143 সংখ্যা. This 143 is a important section. Then persons by the person against whom the unlawful assembly was assembled, এগুলা included হবে. There will be more columns in 345, so that will be added. Subsection 7 এর ন্যূনতম subsection A added হবে basically. So subsection 8 is notwithstanding anything contained in notwithstanding anything. Basically subsection 8 will be added, which talks about notwithstanding anything contained in this section, the court may, where both parties agree to compound any compoundable case, facilitate the compounding process between the parties or refer the matter to the concerned legal aid officer appointed under Legal Aid Act 2000, or to the advocates engaged by the parties, or where no advocate has been engaged, to the party or parties themselves for composition. And if the court is satisfied that lawful agreement has been executed by the parties in furtherance of such compounding, if any, it may preserve the agreement in record and pass such orders as may be necessary to implement its terms, provided that such implementation does not prejudice the right or interest of any third party. Explanation: for the purpose of section, the term party may the person or persons by whom the offense may lawfully be compounded and accused. Section 395 এর বিলোপ, উক্ত কোডের সেকশন হইতে সেকশন বিলুপ্ত হইবে। So section 394 is cancelled basically, and it's not gonna be there, omitted. 396 এর সংশোধন, so in section 396 fine or whipping will be changed and only or fine will be substituted there. And section 413, what is 413? Let me find what is 413. 413 is about no appealing petty cases. 413 is about no, so in 50 taka will be changed to 5,000 taka. Section 414 is about no appeals from certain summary convictions. In here, 200 taka will be changed to 5,000 taka. 498 is about 498. 498 is about power to direct admission to bail or reduction of bail. So in this section, subsection 2 will be actually any court while releasing the accused on bail may impose reasonable and fair condition to prevent his abscondence or to ensure his good behavior. So reasonable and fair condition, very broad thing to say. So it is subject to interpretation, I believe. So section 499 is about bond of accused and sureties. In here, we'll have subsection 3 will be added here. The bond referred to in this section may be submitted to the court by the accused in person or through his pleader or through online system as permitted by the court, subject to verification of the identity and eligibility of the sureties through their national identity number or any other appropriate means. Yeah. So section 540A will be amended. 540 is about power to summon material witness or examine person present. Here in subsection 1, where 2 or more accused are before the court, so there is some difference of comma, there will be a comma thing, so there is like some comma thing amendment, any or more of শব্দগুলোর পর উল্লেখিত such শব্দটি পরিবর্তন দা হবে. So there are some so yeah, so this the amendment is basically, let me say, where 2 or more accused are before the court, শব্দগুলি ও কমা বিলুপ্ত হইবে এবং এনি ওয়ান অর মোর শব্দগুলোর পর উল্লেখিত সাচ শব্দটি পরিবর্তিত দা হবে শব্দ. So that, yeah, it's a very technical amendment, not yeah, so there is a technical amendment. There will be the comma will be not be there, so this is something written here. Subsection 2 পর নিম্নরূপ নতুন subsection সংযোজিত হবে. So there will be a new subsection 3 at the stage of investigation. At the stage of investigation under this code, the judge or magistrate may, for the reasons to be recorded in writing, dispense with personal attendance of an accused person who is on bail and represented by an advocate under the date fixed for hearing of the investigation report. Yeah, so this is the addition. We have section 544, which is about expenses of complainants and witnesses. So that it will be changed to expenses of protection of complainants, witnesses, and victims. This is the change. বিদ্যমান ও সাবসেকশন 1 এ হিসাব সংখ্যায় rules of, so where there is rules, now there will be order. Subsection 2 is added here. Any court may, on the application of an aggrieved person or in its own motion at any stage of criminal proceeding, pass such order or take such steps as may be necessary for the protection or security of any informant, complainant, victims, or witnesses. So more people are added in this section. In Schedule 2, there is amendment where in entry 143, so there are columns in part 143, there will be compoundable where there is not compoundable. In entry 144, where there is ditto, there will be not compoundable. In 325, in column 4, where there's someone is there, there will be warrant, and in column 5, there will be not bailable, where previously it was bailable. Now there is another schedule amendment, form 1A will be added. So where there was form A, now form 1A will be considered. Memorandum of arrest relating to section 46A. We see what are the things that are going to be needed. Name, father's name, husband's name, if applicable, address, age, name, ID, passport, but if available, place of arrest, date and arrest, time of arrest, reason of arrest, name and address of informant, complainant, case, GD number, memo number, and date of warrant of arrest, physical condition of the arrested person at the time of arrest, cause of injury found, arrested, name of the attending registered medical practitioner certification. Has the family relative neighbor arrested person be informed? Yes, no. Name and address of relative, friend, neighbor of the arrested person who is informed, contact number of the person informed, court before which the arrested person is to be produced, signature, thumb impression of the arrested person, of the family members, name, designation, ID number, and signature of arresting officer. Direction: this memo shall be prepared at the time and place of the arrest and shall be forwarded to the magistrate or court together with the arrested person. If the arrested person is injured, attach the arresting registered medical practitioner certification. Release document, show copy must be preserved in the case diary. So yeah, these are the amendments. I hope I've read it correctly. If you find any mistakes or if you find any problem in my commentary, please let me know in the comment section or text me anything in my email, anything. So thank you, everybody. I really enjoyed making this video. Thank you for watching and stay connected. Please subscribe to my channel. Thank you so much.